The recording's been started.
Okay, thanks, Chris. All right, good evening. We're on the record in the matter of encroachment permit application number L-96-S-2687. The applicant is Camp Bay Community Association Incorporated, who I'll refer to as CBCA. My name is Chris Bromley. I'm a private attorney serving today as a hearing coordinator in this proceeding. Today is let's see, what are we? Wednesday, August 25th, 2021, times shortly after 6 p.m. Pacific time. And this public hearing today is being conducted in person in Coeur d'Alene with Mike Amer and via Zoom. So before I open the hearing for comment, I would first like to ask Chris Gozo with Department of Lands to give a brief tutorial on how to use Zoom. My guess is most of us have been using Zoom for quite a bit, but it's never a bad idea to have a reminder.
Certainly. Let me share a screen. Okay. And Mr. Hearing Coordinator, are you able to see that share and everybody else?
I am, thank you.
Great. Okay, so some quick basics on Zoom. Again, a lot of us have been using Zoom for quite a while, but just to touch on the basics again, our key thing is going to be our mute button and our chat functionality. So in your Zoom interface, if you're connected via the Zoom interface, there are some people that have called in with a telephone and they won't be able to have that functionality, but they can still mute their devices as well so that we're not getting any feedback or background noise. But if you're connected via Zoom, in the Zoom interface, in the bottom bar, when you move your mouse down, it may be hidden. You should see a mute button, and that's how you can mute and unmute your microphone. You'll also get an indication that you are muted, as it'll put a line through that mute button. The other functionality is the chat functionality in case we need to send a message to the hearing officer or everyone in the group. If you click the chat button, you'll get a chat window on the right-hand side. And next to the to field, you can click the drop down and select an individual or select everyone if you need to send a message. Sometimes we request that you send a message of your name and email address and organization. And if you need to do that, you can go ahead and put it in there. Other than that, I'd just like to reiterate that we ask that you stay muted until it's your turn to speak. That way we reduce background noise. And if there are any questions, and if not, I'll go ahead and stop the share.
Well, great, thanks, Chris. So this evening, I'm facilitating a public hearing involving CBCA's encroachment application. My responsibility is to consider the application and the written record, take comment, and determine if the application meets Idaho's statutory, regulatory, and case law standards for approval. I'm then tasked by the director of the department with issuing a preliminary order, which will be reviewed by the director, who will then issue a final order no more than 30 days after conclusion of the hearing. The 30-day time limit is a requirement of Idaho code that's particular to Department of Lands. So before we begin, I would like to establish the order in which I will take comment. First, I will take comment from the applicant to provide an overview of the application and offer any comments it wishes to make. Second, I'll provide an opportunity for governmental agencies other than the Department of Lands, if any, to provide comment. Let me ask right now, are there any agencies other than Lands who are wishing to make comment? Okay, hearing none. I'll then take comment from the public. And before I address the order in which I'll take public comment, I would like each of you to know that the written comments that have been received into the record, I've read them, and I provide equal weight to both oral and written comments. So then as to the order of public comment, I'll first take comment from those persons who are physically located at the hearing. And when we talked about that at the outset, it sounded like the gentleman who's there with Mr. Amer at Lands was not going to give comment, but he was there to listen. Is that still accurate? And Mike, you're muted on your end.
Sorry about that, Mr. Hearing Officer. Correct. He's not going to provide any comment today.
Okay, great. So then that makes that easier. So since there isn't anybody physically present at Lands that's going to give comment, then we'll just take comment in order on Zoom. And I think given the numbers that we have, which is a very manageable number, we can just do it as people see fit. If we run into problems with folks talking over one another, we'll take them in order alphabetically on the screen, but I don't think we're going to have any problems with that. So then after we take comment from folks on Zoom, I will provide Department of Lands an opportunity to provide its comments. And just like I mentioned as to written comments from the public, I've also read Department of Lands's hearing statement. So I'm aware of what it says. So then after the department gives its comments, I will then turn it back to the applicant to provide an opportunity for any reply and to make any closing remarks. This is a public hearing in which I'm taking comment, so there will not be cross-examination or questioning by anyone present. That said, I may have questions, so please don't be surprised if I ask any. For everyone who will be speaking, this meeting is being recorded, as we said at the beginning, and because of that, it may ultimately need to be transcribed by a court reporter. And in order for the reporter to accurately transcribe oral comments into a written record, everyone really needs to speak clearly. The reporter can't transcribe hand gestures or nodding of heads or words like or uh-huh. So I may remind you to slow down or to speak clearly or use words like yes and no. If I do this, please know it's not an admonition toward you, but rather just simply to create a clear record. Lastly, please remember to be respectful and courteous of others when they're speaking. Please remember to silence your phone and consider muting your Zoom connection while others are speaking. And if technical difficulties come up, please remember to be patient and we'll do our best to work through them. So with that, I will open the hearing and ask CBCA to please describe the application and provide any comments it wishes to make.
Perfect.
Mr. Hearing Officer, if I could interrupt, I'm sorry. We are getting some background noise from a caller with a number ending in 9836. So if you can please mute your device. Thank you. Sorry for the interruption.
Oh, not
No problem.
Appreciate it. Thank you for the opportunity. My name is Alex Brownlee, and I represent the M3 companies. We are the developer of the Camp Bay property and the declarants of the Camp Bay Community Association. Additionally, attending on the call with us today is Bill Brownlee, partner at M3 companies, as well as we have our engineers from JUB, and we have Rick as well attending in person, who is our legal counsel with regards to the roadway vacation that we completed through Bonner County that was addressed in the Lake Pend Waterkeepers letter. I did submit to Mike a new document we were having trouble submitting the PowerPoint presentation over email. I did not know if it'd be best for me to be able to share a screen and I can walk through that, or how you would like to address the exhibits.
Yeah, a shared screen would be just fine. And I'm sure Chris can do that. And then in terms of making a record, we will need those. So if you can provide those to Lands
I have already sent them in to both Courtney and to Mike this afternoon via email, just to resubmit since we were having issues with the previous submissions that were made Monday afternoon.
Okay, thank you.
You're welcome.
So, Mr. Brownlee, was that a PDF or was it the PDF you emailed me?
Yeah, what I did was I finally just broke it down into a PDF from the PowerPoint, since the files, I couldn't get it to compress to be small enough to get it over without having to put it into a Dropbox or type link. I could share my screen if you'd like, and then that way I can run down through the PDF or the slideshow, however you'd like to do it.
If necessary, you can drop it off.
I have it open on my computer. I'll leave it up to Mr. Gozo if he's okay with you sharing, or if I need to share. I don't know how many people are allowed to share.
Mr. Amer, right now it's only host, but I can change that. So I'll defer to the hearing officer on that. If you'd like to give me Mr. Brownlee, if you'd like me to give Mr. Brownlee access to it, I can.
Yeah, let's go ahead and do that. That'll probably be more efficient because then he can advance the slides as he wants.
Great, thank
Okay, Mr. Brownlee, you should have permission to share now.
you. Okay, sorry here. Let me grab this file. I just accidentally closed it. Apologize for the delay. Okay. There we go. Uh-oh. Is everybody's screen go black there? I think having a connection problem here.
It does look like something's trying to come up now, but it is a black screen still. Oh, now we can see a desktop.
I think I'm losing connection here.
Would you like me to give it a try?
Yeah, that would be great. For some reason, I'm having issues with Zoom, it appears.
Oh, you know what? I just realized, Mr. Hearing Officer, I have my laptop open, but I don't have my I don't have my email open on the
Send it to me.
Okay, so you broke up there a little bit. Let's go. Chris, why don't you stop the recording?
And the recording has been resumed.
Okay, so we were
Yeah.
off the record. This is Chris Brownlee, the hearing coordinator. We're off the record trying to resolve a technical difficulty with PowerPoint that the
There we go.
applicant is wanting to show. We're now
Cool.
back on the record, and Alex Brownlee, on behalf of the applicant, is going to walk us through a PowerPoint.
Great, perfect. Thank you, everyone. I apologize for the technical difficulties here. It's always fun with dealing with Zoom. I'm Alex Brownlee. I'm the development manager of M3 Companies. We are the developer of the Camp Bay project and the declarant of the Camp Bay HOA Community Association. Can you scroll down to the location? I've previously covered the applicant attendees. We have on behalf of M3 Companies, Bill Brownlee, Alex Brownlee. JUB, we have Brad Marshall and Jeremy Russell and Rick Hartharian from our legal counsel in Coeur d'Alene. Camp Bay is located on Lake Pend Oreille, in between the areas for Garfield Bay and Bottled Bay, along the western boundary of the of Lake Pend Oreille. Overall, just to give a brief overview of the Camp Bay property, the Camp Bay property totals 427 acres, utilizing the existing entitlements and underlying zoning and conservation subdivisions within inside Bonner County. We would be able to obtain up to about roughly 55 lots within inside the development. However, the current master plan, which I'll show next, is currently identified for 40 lots, 11 of those lots being waterfront, 29 lots being non-waterfront lots. The community is proposed and will be gated, an access gated community with private roads being maintained by the community association. The gated entry along Camp Bay Road will additionally provide access to the residents along South Camp Bay Road, which is approximately 14 properties along South Camp Bay Road. Currently, we are in process of completing our roadway construction, or in the middle of the roadway construction for our phase 1 improvements, which provide access to the initial 21 lots, as well as one estate parcel on the eastern boundary of the property, with that grading and roadway work being completed in fourth quarter of this year, with anticipation to be paved out by middle of October 2021. The Camp Bay property has been divided into 2 phases, with phase 1 being the eastern portion of the property that you see on the lots 1 through 21, as well as the estate property 1 on the right-hand side, with phase 2 being delineated as the property west of the Camp Bay Road, which is the main north-south road running along the property. And that will be completed under construction is starting next year as well. In Camp Bay, the Camp Bay property has over 3,000 lineal feet of frontage on Lake Pend Oreille, and the littoral rights of the waterfront property have been assigned to the community association, which documentation has been provided to IDL on that, addressing one of the items in their staff report. The community docks are proposed for community use only, with the 29 slips at the community center being available to non-waterfront lots on Camp Bay, and 11 individual private docks along the bay that will be utilized for lots, their adjacent lots. The design of the lots was of the docks was placed into the corner of the bay in order to reduce the impacts inside the bay and in the areas of navigation. Additionally, we've been working with the residents along South Camp Bay to get their concurrence with the design, and was supported by Jim Frank, who is the nearest neighbor along that side, in coordination with the association on this application.
So, Mr. Brownlee, if I could just stop you there a moment. I have not seen a concurrence from Mr. Frank. Was that sent into the department?
I can ask Jim if he can send something in. We've met with Jim personally quite a few times, gone over the design with him. He was contacted by IDL. I did discuss that with him, and I don't believe he submitted anything in writing, but I believe that he told the representative from IDL that contacted him that he was not objecting to the location of the docks.
Thank you.
The boat ramp that is proposed as part of the dock application would be to provide residents of South Camp Bay Road and residents of Camp Bay access to the lake, in reducing the congestion of the boat ramps at Bottled Bay and Garfield Bay. To note, as reported in the IDL staff report, the Garfield Bay, and I do not remember the other location, are only 2 locations on the northern side of Lake Pend Oreille, which we'd be able to provide all season access to emergency services, which we would gladly be able to provide. Previously in the bay, this was a shot before we started construction on the property. There was 21 existing residences that were previously existing, each of those that had a existing dock on the water, as well as many of them had boat sheds that were there. All of the weathered docks that were previously existing have been removed from the lake, and was done so in the winter season with the water at low levels. I've included as part of the presentation, the overall site plan, which was submitted to Idaho Department of Land, showing the locations, separations, and general configurations of each dock as part of the application for the community application. Additionally, each dock was broken down to show the square footage, the length from high water mark, and the lake frontage that each of those lots has in total. totaling allowable square feet up to 21,819 square feet, with this application being at 19,925 total square feet. If you'd like, I can run through each of the docks of the 11 individual docks in the community dock on the conceptual design of those, or we can pass it off back to you, Mr. Hearing Coordinator, and address any questions that someone may have in the future if there is.
Up to you, Mr. Brownlee, your application. I'm happy to hear all of it.
Address boat ramp in compliance with the staff request.
We can, if there's any questions on it, we can then run through that. At this time, I don't know if we'd want to go into the design of each one of these docks unless we need to.
I don't have any questions.
You can stop your share. You can stop your share.
Okay, why don't you proceed? So, Mr. Brownlee, I don't have a video of you anymore. Are you?
Oh, sorry. I was just grabbing a drink there. I'm done with the presentation.
Okay. So going back then to the order, we said we'd open this up to any other governmental agencies, but there weren't any. So then that means we'll take comment from the public via Zoom, because we don't have anybody with Mr. Amer in Coeur d'Alene who wishes to give comment. So if you would like to provide comment, let's start taking comment. Anyone who would like to provide comment, let's try and see if we can have you start talking, and if we have folks talking over one another, we'll work it out. But let's take any comment from anyone who wishes to provide it.
Yeah, my name is Steve Holt with the Lake Pend Oreille Waterkeeper. I'd appreciate an opportunity to comment.
Great. Okay, so we have Steve Holt with the Lake Pend Oreille Waterkeeper. Thank you, Mr. Holt.
Yeah, and thanks M3 for the presentation. I think there was some clarification that came there for me. But to start off, I wanted to thank the Department of Lands for holding the hearing and giving us all an opportunity to speak. I apologize for not submitting a second round of written comments. I have been traveling and just got back yesterday, but I do have something that I wrote that I'll sort of read and paraphrase from as I go, just to sort of keep me on track so that I can, make the points that I want. I'm happy to provide a copy of it if it would be helpful. But
yeah, Mr. Holt, before you start, if you have something in writing that summarizes what you're going to state tonight, if you can provide that to Lands by noon tomorrow, yeah, then I'm happy to take it. I like having things written down. It helps me go back. And so the same goes for other people. If you've got something that you were wanting to show today, we'll take them up until noon tomorrow.
Okay, and would I send that to you directly?
Let's have you send it to Mr. Amer.
Okay.
And do you have his email?
Yeah, I do.
Okay, I sort of figured you might. So let's do it that way, and then that way it'll get to me and it'll become part of the record. So thanks, Mr. Holt. Off you go.
Yeah. So like I said, I appreciate the opportunity to speak. Our office got involved because I got numerous phone calls from adjoining property owners and people who lived down on Camp Bay Road. And we got involved, made an initial round of comments, and then requested the hearing. So I appreciate that. And when I initially looked at this, and I think this is clearly a potential loophole that I think the Department of Land should pay attention to in the future as it relates to the littoral ownership. But if we were to take that piece out of it and look at this as simply a subdivision, which has been approved at this point. So there's a 21 lot subdivision that's currently approved, okay, with the 7 waterfront lots, and then 1 lot that is sort of community owned. So if you were to take, apparently, the applicant has taken the 3,117 lineal feet of shoreline that it owns and multiplied it times the 7 square feet of community dock that it's allowed for community dock, as if the entire thing were a community dock, to come up with a total of 21,819 square feet of allowable dock. And like I said, this is as if they were to own the entire shoreline. And then in addition to that, they've also assigned docks to 4 estate lots that are currently on a parcel that has not been subdivided yet. And so if and when this lot, it's our opinion that this particular parcel does not qualify for the 4 docks, given the fact that it hasn't even been subdivided. There's been no public hearing on it. It hasn't gone to the county. There's been nothing that has been done on it. So, when we read IDAPA 2003-04, it allows for 700 square feet of dock per parcel of land. So as these lots get sold, and they are currently separate lots right now, realistically, you have 7 waterfront platted and recorded residential lots and 1 community lot. So if you did the calculation based on those numbers, you essentially get 7 lots at 700 square feet per dock for a total of 4,900 square feet. And then if you took the remaining community-owned dock, which has 306 feet, lineal feet approximately, más o menos, of waterfront, you get another 2,142 square feet, which would then allow them only 7,042 square feet of dock. And they're able to, through apparently this littoral ownership, come up with a calculation that gives them over 20,000 square feet, which just seems completely unjustifiable and unrealistic for the size of the development that they have there. In addition to the fact that I'm sure that the docks that are sitting forward of those individual 7 lots are for the private use of those 7 individuals and not spread out through the rest of the community. So I think it's disingenuous to try to say that all the littoral rights will be owned by everybody in the subdivision, regardless of what the sort of legal papers say. So I think that, and as I previously mentioned in some of my comments, there is a petition for judicial review was filed, against the Bonner County Board of Commissioners right now, contending that the vacation of the road leading to the water was not in the public interest. And we, after talking with the attorney for the person who filed that review, we feel extremely concerned that the county will be found guilty there, and the road will be reopened to the public, which would make for major adjustments to the location and the physicality of those particular docks. And then above and beyond that, if the petitioner is successful, and I know this is not the Department of Land's issue. This is a Bonner County issue, and we're dealing with it all the time. But they allowed 21 leased lots to be converted to basically substandard lots. They don't meet the zoning requirements for the size, for the zone that they sit in, to be processed and recorded, all without a preliminary plat process or public hearing, which we feel may further be challenged in the courts. And so with all that, we just feel like there's a lot of, we're not anti-development, the Lake Pend Oreille Waterkeeper. We're concerned and we want people to use their best management practices. But when we see these kinds of overreaching projects out there that could have implications for water quality, it's a concern of ours. And then the other thing, just backing up on the square footage of the dock issue, we have 700 square feet of dock, that's supposed to be assigned, per residential lot that has waterfront. And now all of a sudden we have docks that range all the way from, I think it was 1,090 square feet to 1,720. So just this ability to be able to say that the littoral rights are owned by the entire community has mushroomed these numbers into things that I believe are contrary to IDAPA and contrary to the law that the Idaho Department of Lands is there to protect. So, in summary, we feel like that it would be prudent for the Department of Lands to really evaluate this project. Under IDAPA 2003-04-015 encroachment standards, it's item 02C. In the last paragraph states, quote, the department, meaning the Department of Lands, at its discretion, may limit the ultimate size of dock square footage when evaluating the proposal and the public trust values. And we would just ask that we contend that, this application violates those rules. And we also believe the application for the individual community docks were approved. Those permits should hold if in fact you do approve permits. Okay, and I'm sure you will approve some permits at some point. I can see there's no really stopping that. But those should be on the condition that the current legal challenges that could result in either a lot line adjustments or a complete elimination of the entire subdivision if somebody were to challenge this in the court, be settled prior to the physical construction of any dock that is out in the bay. We feel this is an especially pristine and sensitive area that has been enjoyed by many, throughout history. While we understand the need to grow, we feel this project is simply, too much. And I feel I appreciate, where the developers are coming from. I've done a lot of that myself in the past, but when you come in with, heavy-handed like this and shut down the road and cut people off and, create, these astronomical quantity of homes on a parcel of land in which a woman, dying wish was to have this thing put in a conservation easement. She was a conservationist. She donated Pearl Island to Fish and Game. So, just incredibly, community oriented, and really wanted to make sure that this, property, remained, natural in an easement and for the public and everybody to enjoy there. And so this sort of a development approach that we have here is obviously going to bristle the backs of some people. And, you put 50 houses out there, 55 with 50 boats, and you are loading nutrients, into that bay, it will never be the same. This project currently does not even have a wastewater disposal approval from either DEQ or Panhandle Health. And in my initial conversations with Panhandle Health, septic systems are just off the table on this, right? It's not going to happen. So now we're into these big community systems, which aren't even shown on the site plan. So while I appreciate the work and the flair and everything that the developer has put into it, there are some serious infrastructure things that I feel like are being neglected here. And the way this project is just rolling without understanding complete approval, I feel like the Department of Lands is putting itself in a lot of jeopardy if it approves this application and allows these docks to be constructed prior to the final approval, and conclusion of any legal issues and lawsuits that are coming down the line. So I think I'm starting to repeat myself, so I will stop. But thank you. I appreciate the time.
Thank you, Mr. Holt. So other comments? Anyone else?
This is Gary Green on audio. Can you hear me?
I can, Mr. Green. Let's
Okay.
take your comments. Thank you.
Okay. I am a 10% shareholder in Green Enterprises, which sold the property to M3. First, I want to say that I think the placement of this dock, it's inexplicable to me why Idaho Fish and Game gave approval to that placement, because that's a kokanee spawning area right there that I can personally attest to seeing schools of kokanee swimming in that area in November of 1954, and again in about November of 1973. When the lake level is drawn down in the fall, the creek in that corner does not cut through the gravel. In fact, the water, in fact, flows through the gravel and upwells and creates a perfect spawning gravel for the kokanee. And if you go down there in November, you'll see bright red fish swimming back and forth. And so I think that's something that was missed. The next thing I would note is that the Ralph and Jean Green Revocable Trust had a 4th and 5th Amendment that required the land to be placed into a conservation easement, and if it wasn't, that the Girl Scouts, Boy Scouts, and Gamlin Lake Cemetery were to be the beneficiaries of the trust. James Green was the trustee, and I have no information that he has notified those organizations that they are rightful owners of the property. And there was no conservation easement in place within 1 year after my mother, Jean Green's death. So there's an outstanding issue of whether the James Green had the right to transfer to make this sale. I'd also note, as a 10% shareholder, that this was filed a long time in the past. I think it was May or something like that. And as a shareholder, there was no notice to the shareholders that this dock application was in place. We have an agent for us, Eric Skinner, who did not inform us that this was in progress. So I think it's wildly premature to be authorizing something where there are so many legal issues at hand. I found the discussion of front footage troubling because we've seen front footage numbers as high as 3,500 front feet at times, and 3,000 at others. And so, you know, I don't even think the front footage of the property is accurate without some remeasuring of it, because we've seen appraisals done where 500 feet was just mysteriously lopped off to make the property look less valuable. So those are my comments.
Okay, thank you, Mr. Green. Anyone else?
Yeah, this is Randy Green.
Okay, hi, Randy.
Hi. Yes, I am also a 10% owner in Green Enterprises. I'm the grandson of John Van Scravendijk, who homesteaded this property in 1902, and his daughter, Jean Green, my mother, was his only child, and it was her wish that a large portion of this property was going to be placed into a conservation easement, and I'm appalled that the state of Idaho is ignoring the trust documents that have been filed by my mother, and that James Green has filed other documents over and over again stating that he was going to put a conservation easement on this property as part of the agreement to receive the majority shares, and he lied. He did not follow through on those. And I find this really disturbing because this is not what my mother wanted done with this property. And I'm appalled at what's going on. Regarding the docks themselves, no one historically has ever left their boats at the docks overnight in Camp Bay because of the geographical orientation of the bay. It gets nightly swells every night during the summer, and the docks will just bang up against the dock and potentially cause pollution due to damage. Not to mention the fact that there's 50 boats in the bay over 24 hours a day is just going to cause an insane amount of pollution. I can't even begin to think that we're seriously considering putting this number of boats in the bay. In addition to that, the way the docks are oriented, the ones on the lots 4 through 6, I believe, 4 through 7, they're all facing essentially towards the open lake. And the swells will come in nightly through there, and they'll be hitting the back of the boats and just jostling them like crazy. And the way the community docks are oriented, they're going to be hit head on, and they're just going to be going up and down all night long. And the next thing I see is that the M3 will be asking for a breakwater, and Camp Bay will get its little breakwater of tires, just like Garfield Bay. And we really want to make this place that ugly? There's a part of the it says that the docks must be designed and installed to withstand normally anticipated weather conditions, and it doesn't appear to me like they've even taken into account the geography at all. This is the widest part of the lake. It's straight across from the Clark Fork Gorge, and when you get winds coming down there, you got 7 miles of open water for waves to be created, and you're just these are going to be buffeted like no get out. Nobody has ever left their boats there overnight, and so I don't know if this has been taken into account at all. And it's just not going to work. I mean, it's never worked in the past, and with and there's really no telling what's going to happen to the gravel, because whenever somebody's altered the shoreline on the north side of the bay there, there's always been some sort of reestablishment of the gravel based on or, you know, from the altering of the waves. And I don't know, it just doesn't seem, this seems to me like it's just been drawn by somebody who's a draftsman, and that's it. And they've got no idea about the geography or the weather conditions. They've not been taken into account, and that's one of the major things that it says that the Idaho Department of Lands requires to be taken into account is weather conditions, and they obviously haven't been. And I can tell you, I've been going up this place. My first experiences in life were 3 years old, living up there for a year with 1954, and this isn't going to work this way. And I'd like to also agree with my brother that this is the corner they put the community dock in is the worst corner they could possibly put it in, since that is the outflow from Livermore Lake. And that is where there is an incredible amount of biological activity. And, you know, they're just going to pave it over. You know, this is outrageous. I sent in one other thing too is that I wanted to say was they said in their presentation that these 21 lots had docks. That's not true. These lots did not all have docks. For instance, FAM 1 or FAM 4, I can't remember which one it is, that James Green is currently leasing from them for a remarkably small sum. That one's never had a dock. Several others never had docks. And matter of fact, I don't even know how they managed to move 2 of the lots, and the family dock lots, because they haven't had a cabin there for about 7 years. So I'm not even sure how they managed to move those in the 21 lots. They kind of forgot to mention that they'd been torn down years ago. So I'm not sure what to say other than the fact that this is a horrible way to take a pristine bay and just fill it full of boats that are going to be leaking oil and gas. We've seen marinas. We all know what marinas look like. It's horrible. I'm appalled at this. Here's my comments.
Mr. Green, if I could just ask you a question now that I've heard from 2 Mr. Greens. There's an affidavit of legal interest that is signed by a James Green, who's president of Green Enterprises.
Right.
And your relation to James Green is what?
He's my oldest brother.
Okay, and are all of the Mr. Green's brothers?
Yes, Gary is my second oldest brother, and yes, James is the majority stockholder and has promised that he would legally promised that in order to take ownership of majority shares, he would put in a conservation easement on this property of over 200 acres.
Okay, so then you're a 10% shareholder, and
I'm a 10% shareholder, and I did not find out about this. You know, I was not notified I wasn't even notified by the corporation that they were putting in the 21 lots, let alone, you know, that he was approving, you know, letting them talk to the county about. I wasn't about the docks. I wasn't informed about the road vacate, which is another thing. I mean, that's another legal issue that's going on. And my grandfather gave permission for the county to have that road go down to the high water mark. Now, I understand that high water mark is a legal definition that varies, you know, back and forth. But the bottom line is he didn't say it was like, X number of feet or anything. He just said high water mark. And that's where all of the leases went to, also was a high water mark. So that road went down to basically to public property, and that whole beachfront there should be public property.
Is there any litigation over this right now in terms of
Yes,
within Green?
my understanding is the road vacate is still being litigated, and this as that they could very well decide the South Camp Bay Road goes off of Camp Bay Road and follows the shoreline there, where they want to put the docks in.
Okay, thank you, Mr. Green.
You're welcome.
Any other comments?
Yes,
I saw a hand from was that Cathy Lafleur?
Cathy Lafleur, yes.
Hi, Cathy.
Hi, I'm sorry, I'm new to doing this, so I might be a little bit.
I can hear you just fine. So let's make your comments. Thank you.
My name is Cathy Lafleur. I am the daughter of Ralph and Jean Green, the granddaughter of John and Kate Van Scarabendijk, the homesteaders of the property. I want to comment because you've heard from two of my brothers. We have a developmentally disabled sister who is now basically living in poverty because she was disinherited. Our oldest brother inherited all of it. The estate attorney that did the final amendment said that Jim inherited it all because our parents believed he would not develop the property and he would put the conservation easement in. He's brought in his stepson as a director and his brother-in-law as a director. And the biological family has been held out. We don't get any information about what is going on in the corporation. Last week, we just got a ton of documents dumped on us with only 2 or 3 days to go in and vote on a dissolution of a corporation that was formed to pass the property on to my mother's descendants and keep it in the family. It's been in the family 120 years. It's just, if any, I don't know why there's not more caring about what a woman, what she wanted and what she worked for in her lifetime was to pass it on and take care of her developmentally disabled daughter as well. So I'm trying, my mother's deceased now. I'm speaking for her. She doesn't have a voice now, but I heard her repeatedly over her adult life tell me one of the worst things that she thought could happen would be to have a gated community. She grew up in nature out there. She gave Pearl Island to the citizens of Idaho. I think her developmentally disabled daughter deserves more than $800 a month in trying to collect cans here in Portland as deposits. We have been so held out of all of this. And this may be my only chance to make a public statement of what my mother wanted, and on behalf of my sister, who doesn't have a thing and is struggling here to get by. So all these wealthy people coming in, paying millions of dollars. Why wasn't the family ever involved? Why wasn't the family ever asked if they would want a lot on this? Everything was sold and done before no one contacting us, no one. And the log house to me is sacred. It was awful to see just a couple of weeks ago that it's a curtain is flying out of the window. It's falling apart. My mother was born in the living room. My grandmother died in the living room. I was almost there with her when she died. And it's just being trashed and run over. So we're a pioneer family, a part of the history of Idaho. And the photos go back to the early 1900s of my Uncle Henry homesteading on Pearl Island, my grandfather homesteading, and my mother wanting to preserve that forest for the memory of her father. This is not at all what we wanted as a family. Thank you so much for listening. Appreciate the time.
Thank you, Kathy. So the question that I had asked Randy, and I should have re-asked it, is there litigation within Green Enterprises as to what Green Enterprises can and can't do in terms of conveying ownership of something?
Well, I did just file an injunction last week that it wasn't to be dissolved, but they went ahead because I was trying to block it so my younger intellectually developmentally autistic sister could be taken care of before all the assets were given out. I think it's just very unfair that it's going to stepchildren that have no relationship. That's my comment.
Did you file that in Kootenai County?
Bonner County, it was filed last Friday.
I'm sorry, that's my mistake. I meant to say Bonner.
Yes, it was filed Friday afternoon. The attorney is Todd Reed.
Okay, thank you. Other comments?
This is Eric Skinner. I'd like to comment, please.
Sure. Hi, Mr. Skinner. Go ahead.
Hi. Thank you, and thank you for hearing this tonight. I'm kind of in a strange position here because I represented Green Enterprises through this entire sale, and I'm only too familiar with this whole process. And I've been working. I worked for Green Enterprises for just shy of 3 years, I believe it was, and this is a highly frustrated group. This all started, one of the things that was said a minute ago was their older brother Jim was put in charge of the family estate because he would put it in a conservation easement and all this. The kids, there are 4 kids, there's 5 kids of their mother and father that passed this property on. There was a corporation created, and I'm just going to give you a very fast version of this, but this has gone all the way to the Idaho Supreme Court. These are minority shareholders, and they have every step through the process, they have tried to frustrate the sale. They've tried to frustrate the road vacation. They've tried to frustrate this. And I just think it's disingenuous for you not to understand what all is going on here. There's a lot more to this story. Basically, a corporation was created. 4 kids were all given 10% ownership of this property. A few of the kids, 3 of the kids decided at one point, and it's much more involved than I could ever share, but 3 of the kids had decided to sue the corporation and the mother, who was the head of the corporation, because she had 60%, because they thought there should be more income coming in on these 21 cabins that used to be down there. The long and the short of it is, shortly after that went to the Supreme Court, the parents passed away. Ultimately, they gave their shares of the corporation to the one son that wasn't part of the lawsuit. They then sued him. It went all the way, I believe, to the appellate level. And I could have this a little bit backwards in how this went as far as which came first, but this is not a situation where they weren't involved. There's several comments made that things were done without them knowing about it. Everything in this process. And by the way, I represented during that process, during the sale of this property, I represented Green Enterprises. I did not represent M3. And the contract that they wrote clearly stated that out. And I represented the majority, I represented Green Enterprises, but the majority of Green Enterprises, the majority shares wanted this property sold. I went through and met with the board on all these issues, on everything that came up. Everything went through the board of directors for Green Enterprises, and everything went through the corporate attorney for Green Enterprises. So this is just another step of the frustration of the process anywhere they can, because they ended up with the minority ownership. I also want to state, prior to M3 even getting involved, just because I think background matters. Prior to them even being involved, I met with Randy Green. I asked Jim Green if I could meet with his brother Randy down in Coeur d'Alene and review the sale. And one of the things I suggested to them is, if you guys, based on your ownership piece, want a piece of land and some waterfront, tell me what you want. Let's see if we can work it out. Let's see if we can figure it out. It was almost a 2-hour meeting down in Coeur d'Alene, and we got nowhere fast. It was all about all the old junk that happened. We never got to any real business about how to give them something. So I just want you to know that this went through a board of directors. This went through corporate counsel, every bit of this. And I have reached out to the council, and I'm going to have them try to submit something to you by tomorrow at noon, to kind of give you a little bit of this background, so that anything that I'm making a mistake on here can be cleared up there. But this isn't a situation quite like it's being painted. Every step along the way, this has been frustrated. Last thing I'll say, unless you have any questions for me, is the pollution part almost makes me laugh, because these 21 cabins from the 50s had all kinds of crazy stuff going on down there right next to the water. By pulling all those out and pulling out all the man-made materials that were down there that we've done, M3 has done a phenomenal job of cleaning this bay up, and they should be commended for the work that they've done there. And the whole situation of my dad gave the rights all the way to the high water mark. Bonner County, in reviewing all the roads and the where the different roads met, and they looked at the Metzger maps and all that stuff, it was determined at that Bonner County hearing that the road vacation could happen because there was no public access down there. So, you know, a lot of this is regurgitating things that had already been addressed or litigated or whatever. So I kind of wanted to pass that on. Now, in full disclosure, I now work for M3, and M3 asked me when meeting with me that in the end of all this, if I could work with them. And I disclosed to the Green Enterprise Corporation that once I got the property sold for them, that I would be working with M3. That was from the very beginning. That was disclosed as well to the board and everybody. So it's not like I, after the fact, came back and started working for M3. That was all disclosed from the very, very beginning of this. And I've been tied into this for about 3 years. So I just wanted to share that.
This is Gary Green. I would like to, I'm not going to rebut what Eric Skinner said. It contained a number of falsehoods, but I'll try to touch on some of the prominent things. We were told in the sheriff.
Mr. Green, this is
Yes.
Chris Bromley, the hearing coordinator. Before you start, so Mr. Skinner, you mentioned something about having council draft something up that, you know, might or might not contradict what you said. I'm not interested in seeing that. I'm not going to take that into the record. I was interested in what Mr. Holt was saying earlier, because it appeared that he was trying to read from a document that he had written. Was happy to take that into the record. I've heard your comments, and you know, I'm not going to take something into the record that's going to be drafted up after the fact as a rebuttal, if you can appreciate that.
I absolutely can. I just was attempting to help you in the understanding of the history, and for me, it's the timing. I don't have all the timing because it was before my time.
Yeah, and that's perfectly fine. I completely understand that. So
okay,
thank you very much.
Thank you.
Now, Mr. Green. Now, and which Mr. Green was this again?
Gary Green.
Okay, Gary Green, happy to take your comments now. Thank you.
Okay, I appreciate you following this process because in the road vacation, the rules weren't followed as meticulously, and the attorney, John Magnuson, was allowed to examine my comments, written comments, after the closing time and enter disagreements to my comments that I was not able to rebut. So I appreciate you observing a legal process. I want to say that my understanding from a shareholders meeting in which we had an extreme difficulty extracting from Eric Skinner what his commission for the sale of Green Enterprises property was. My understanding that his commission was to be 2.5% from Green Enterprises, 2.5% from M3, and the right after M3 acquired the property to receive a commission from them. That meeting should be available as a Zoom recording to resolve that discrepancy between what I am saying and what Eric Skinner is saying. Our cases have not been heard in court. This went to, an appeal went to the Supreme Court, but it was an appeal of a summary judgment in which documents were dumped on us, and 2 weeks later we got a summary judgment against us before we had time to even digest the documents. Our attorney failed to represent us by not asking to have the summary judgment held in abeyance until we had a chance to examine the documents. We did attempt to assist our mother by filing a guardianship conservatorship, and in that proceeding, the medical records of my mother were not provided, and we have since learned that it was known that my mother had moderate memory impairment years earlier, and we learned after, a few months after, that our mother had Alzheimer's. So there's much left to be litigated in these things. And Eric is right. He's coming into this very late. And he doesn't know what he's talking about. And he repeatedly represents himself in different roles. On Saturday, Eric Skinner was representing himself as an IT service provider to Green Enterprises for a Zoom meeting that was being held. And he claimed he no longer had, a day or two before, he had claimed to me that he no longer had any relationship with Green Enterprises. Now he's in here representing M3. This man is so flexible, it's unbelievable. That's my comment.
Okay, thank you, Mr. Green. Mr. Skinner, I'll give you just a little bit. I completely understand that what you're interested in here. And let me just make a statement before before you speak, and I'm more than happy to let you speak. There's a lot of back and forth going on right now. I understand that sounds like there's plenty of things going on. Completely get that. You know, the task here tonight is to take comment on the dock application. And so focus back in on what's at issue, which is the application that has been filed relating to this dock. And Mr. Skinner, if you want to say something, I'm happy to let you respond. And then I'd like to focus back on the application.
Yeah, and that's actually what I was, thank you. That's exactly what I wanted to say, is this should be about the applicant and the docs and not all this other stuff. I think it was important for you to understand that there's a lot more going on here than meets the eye. And I'll just reserve everything else that I would love to say, but because I know no one cares to hear it. Thank you.
Okay, thank you, Mr. Skinner. So let's take other comments on the application, please.
I'd like to make a comment.
Okay,
This is Cathy Lafleur.
okay, Cathy, is it a comment about the dock?
Well, it is.
Okay.
And it's a comment about not being informed, not being asked if I would like to have a lot, if I would want a dock. Eric Skinner said he met with Randy, but I was never contacted by Eric Skinner. I also want to state again, he said he had many meetings with the directors. The directors were Jim, a stepson of Jim's, and a brother-in-law of Jim's that did not know my mother. And Jim had a long history of wanting to develop it. My parents did not. In their very senile years, they came to believe Jim was the one that would not develop. And after he got control, he eliminated his biological siblings and brought in a stepson and a brother-in-law that didn't know my parents and what they wanted. So that's my comment. He could have had many meetings with them, but the biological family has not been included in knowing what's happening. We only are told months later afterwards. Thank you so much for letting me make that comment.
Okay, thank you, Ms. Lafleur. Let's please work through folks who have not been able to provide a comment yet. So I'd like to hear from anyone else who I have not heard from yet.
Mr. Hearing Coordinator Bill Brownlee. Are we
okay, Mr. Brownlee, if I can ask you to
these comments that have been made.
Okay, Mr. Brownlee, if I can please ask you to okay, one, we're getting a lot of Mr. Brownlee, we're getting a lot of feedback.
Are we okay now?
Second, Mr. Brownlee, my understanding is that you work on behalf of the applicant with M3. To the extent that M3 or the applicant wishes to make comment, I was going to then take that at the end, which is what I said at the beginning in terms of the order of comments.
I'm sorry. Yeah, I'm the owner of M3, so I'll wait till the end. Thank you.
Okay, thank you. So anyone else who is not the applicant, not Department of Lands, and not another Idaho agency who would like to make comment?
Mr. Hearing Coordinator, the person who's here in the conference room would like to comment after all.
That's perfectly fine.
Actually, Mr. Hearing Coordinator, I kind of defer to you. It's going to be in terms of the vacation issue, which is simply not a bar here. So if you'd like for me to comment, provide elaboration on that point, I'm happy to do so. But if not, since that issue has been raised, defer to you.
So, yeah, the road vacation issue, which is an uplands issue, which is not something that's below the ordinary high water mark. I agree with the statement of IDL that is outside the scope of this proceeding. And so on those points, still, if you would like to provide comment, I'm, happy to take it. But if you'd rather not with that explanation, up to you.
I appreciate that, Mr. Hearing Coordinator, and I think that's exactly the perspective and exactly the point that I wanted to make.
Okay, thank you very much. Anyone else who would like to provide comment on the application, again, who's not the applicant, not an agency?
Randy Green, if I could make one more comment.
Sure thing, Mr. Green. Let me just ask though, is there anyone else who hasn't provided comment already who'd like to provide comment? Okay, hearing none. Mr. Green.
Yes, thank you. First of all, I'd like to also say that Greg Skinner has a lot of things wrong in his understanding of our lawsuits. But I would really like to I guess basically beg M3 to follow their commitment to creating communities that honor and advance the timeless heritage of the West. The log house there that my grandfather grew up, used to homestead. Actually, my great-grandmother lived in that. My grandfather lived up in another place up further back up behind. My great-grandmother Anna was also a homesteader there, Anna Van Scravendijk. That house was where my mother was born. My mother was literally born in a log cabin. And I've sent an email to M3 asking for permission for the family to go through there and get personal effects out of there before it's torn down, and I've heard crickets. And I just see this as, an example. If this is the example of how you are going to treat Camp Bay, I'm appalled. And Idaho Department of Lands, I beg you to not let these people just despoil this bay. It is beautiful. And to put the number of boats in there that they want to put in it's unheard of. It's just, they're dumping it on a biologically active area. And I don't know, they just don't seem to care at all about the welfare of the bay. Thank you.
Okay, thank you, Mr. Green. So hearing no one else raising a hand or asking to speak, Mr. Amer, I'd like to turn it over to you to provide the department's comments.
Thank you, Mr. Hearing Coordinator. I'd like to start off by addressing some of the comments that came up today. At the forefront, with the waterfront lots, they are giving up their littoral rights. And the way the application is being presented, you get 7 square feet of dock space per every lineal shoreline foot that is owned. This is very similar to other community docks that IDL has permitted in the past, such as Sourdough Point on Lake Pend Oreille, and also Ridge at Sunup Bay on Lake Coeur d'Alene. Ridge at Sunup Bay on Lake Coeur d'Alene, if you were to look at the Kootenai County parcel ownership, it would appear that there's 10 waterfront lots, and they all have a dock out in front of their waterfront lot. But all of those waterfront lots do not actually own their littoral rights. The littoral rights were given to the community, and that's what's happening here. I'd also like to point out that IDL relies on our sister agencies for their commenting. That is part of why I believe that is an IDAPA for us to submit comments to the agencies. I am by no means an expert in water quality, so I submit to Department of Environmental Quality for their expertise, just like I do for Fish and Game and Department of Agriculture for aquatic invasive species or fish and wildlife. We need to rely on their expertise to comment and use their expertise accordingly. I'd also like to mention that the 3,100 feet is what I also came up with when measuring on Bonner County viewer. I also would like to state that if it does turn out that there are legal problems with the ownership that affect littoral ownership, it could affect the permit. But based on the information IDL has or had, it appears that the conveyance of the property was legal. So with those additional comments, I'll start with my statement. Good evening. My name is Mike Emer. I'm the Lands Resource Supervisor for the MICA Supervisor Area Office of Idaho Department of Lands. I'm also the supervisor of the Navigable Water Program at IDL. My purpose in being here today is to provide you with information regarding IDL's assessment of application for encroachment permit number L-96-S-2687 filed by Camp Bay Community Association, or CBCA. CBCA is seeking an encroachment permit for a community dock system located northeast of Garfield Bay on Lake Pend Oreille. The proposed community dock system will consist of 11 docks in front of a waterfront, but as mentioned before, littoral rights are actually owned by CBCA parcel, 2 multi-slip community docks, and a boat ramp or boat launch. As far as the timeline goes, on May 13th of 2021, IDL initially received an application from CBCA. On 5/28/21, IDL receives the complete application for a community dock system at Camp Bay. On May 27th and June 3rd, IDL contacted Bonner County Daily Bee newspaper to advertise the application. On June 4th of 2021, IDL sends a copy of the application to local resource agencies for their review and states that the deadline to submit comment would be July 6, 2021. Also on the 4th of June, 2021, IDL sends a copy of the application to adjacent neighbors. On July 1st, 2021, IDL receives comment regarding the application from Idaho Fish and Game. And then on July 6th, 2021, IDL receives written objection and the $75 publication fee from Lake Pend Oreille Waterkeeper. On July 30th, 2021, IDL's director issues a notice of appointment of hearing officer and hearing. And then on August 13th and August 21 of 2021, the advertisement regarding the time, date, and location of the public hearing is published in the Bonner County Daily Bee newspaper. The next section of the statement, and the next several pages, deal strictly with the applicable legal provisions with the Lake Protection Act, 58, Chapter 13, as well as IDAPA rules. I will skip over those since those are already in the statement, and I will forward on to Section 3, which is IDL's analysis of the application's compliance with the LPA and LPA rules. As far as littoral ownership, at the time the application was filed, littoral parcels were owned by Green Enterprises. According to Bonner County records, M3ID Camp Bay LLC now owns 9 littoral parcels on Lake Pend Oreille with approximately 3,100 feet of frontage. In the first page of the application package, M3ID Camp Bay LLC stated that all littoral rights will be assigned to CBCA. IDL recommends that as a condition of approval of this application, CBCA be required to provide evidence in the form of a deed or a lease that it is the owner of the littoral parcels or of the littoral rights. Type of encroachment?
Mr. Amer, if I could just interrupt you there, and let's talk about that Section A littoral ownership.
Okay.
So you say the littoral parcels were owned by Green Enterprises, Inc., and that now, according to Bonner County records, M3 owns 9 littoral parcels. Are those all of the littoral parcels, or are there others that are not owned by M3 that are still in the name of Green Enterprises?
According to Bonner County, there are no other parcels owned by Green Enterprise. The far eastern lot that is referred to as an estate lot shows up as ownership as Camp Bigfoot LLC. But the other parcels are all owned by M3 ID Camp Bay LLC. There are no parcels owned by Green Enterprises. When the application first came in at the beginning of May, it hadn't been referenced yet in Bonner County. It's my experience that Bonner County and Cooney County, their web pages take a little while to update.
Okay, so the 3,100 linear feet of frontage, is that all now in the name of M3?
No, it also includes that Camp Bigfoot LLC.
Okay, that was sort of what I was thinking I was hearing you saying. So there's a Camp Bigfoot LLC that is the far eastern estate lot. Is that what you said?
Correct. That's my understanding of the application and what I'm looking at on the Bonner County viewer.
Okay. So M3, when it comes back to you at the end, if you could help me understand the ownership question, I would appreciate that.
Yeah.
So Mr. Amer, the 3,100 linear feet, then that's both, as your understanding, that's both M3 and this Camp Bigfoot, if I heard that right. Is that correct?
Correct. That's my measurement. That's what I came up with, was including the Camp Bigfoot. And through discussions with M3, it's my understanding that all of the waterfront, all of the littoral rights of the waterfront lots are given to the community, similar to Sourdough Point and similar to Ridge at Summit Bay.
Okay, but if they don't own this Camp Bigfoot parcel, and we'll get that cleared up, then the 3,100.
I believe that's why the hearing statement recommends that as a condition of approval, they provide evidence in the form of a deed that it's the owner of the littoral parcels or of the littoral rights. I believe, and maybe my legal counsel, Angela Kaufman, could chime in. She helped draft this statement as well, and that section actually was adjusted.
Well, so yeah, let me just continue here. The number is important because it goes to calculation.
Correct.
That's correct, right?
Correct.
And so with IDAPA using the 7 square feet, all of this is going to calculations that you're then making in your hearing statement. So I'm wanting to make sure then that the numbers that I have, that I then multiply, that I have the correct numbers, if that makes sense.
That does. I would add that based on the discussions with M3 and based on requiring them to prove that they're the littoral right owner of all of the parcels, Department of Lands would not accept an application from Camp Bigfoot because it appears that their littoral rights have been used up for the community. So there wouldn't be a case of double dipping.
Okay, thank you. I appreciate that. Okay, let's go on.
Okay. Type of encroachment, they're seeking an encroachment permit for a community dock system totaling 19,925 square feet. The application type would be considered navigational encroachment. Shoreline length, as stated before, the length of the applicable frontage is approximately 3,100 feet. Square footage of encroachments, as we were discussing before, IDAPA 20.03.04.015.02 states that community docks may have 7 square feet of dock space per lineal foot of shoreline owned or leased, or to which the applicant holds the rights. Based upon the application, CVCA has or will have littoral rights for 3,117 lineal feet of shoreline and would be eligible for 21,819 square feet of dock. CVCA has submitted an application requesting 19,925 square feet and is therefore within that limitation. The line of navigability, the proposed dock system would extend outward into the lake a maximum of 206 feet for the largest community dock. There are not many existing docks in the immediate area. The existing docks on the north shore of Camp Bay are older docks that used to serve cabin owners on the property, as has been discussed previously tonight. With the exception of a few docks on the south shore of Camp Bay, the docks are also older and shorter. However, the proposed dock system does not extend beyond the ordinary high watermark on Lake Pend Oreille, and due to the curvature of the bay, the dock system does not appear to be a potential hazard to navigation. Distance from littoral lines, IDAPA 20.03.04.015.13.E set forth the presumption that a community dock does not, if a community dock does not provide at least 25-foot setback from the dock to the property line, it would result in an adverse impact to the adjacent neighbor. The proposed CVCA community dock appears to have a 55-foot setback on the south side of the bay and a 102.5-foot setback on the north side of the bay. Conclusion, the dock drawings. Yes.
Let me interrupt you there again. There was a statement that was made at the beginning by Mr. Brownlee, and I think it was in relation to Mr. Frank. The Franks, have you received anything from the Franks saying that that they don't oppose? You know, my understanding is they were notified as littoral owners, and I've seen in the past documents come back in to say that certain littoral owners don't oppose the application. Have you received anything like that?
I have not received anything from Mr. Frank, but I will note that Department of Lands has been working with Mr. Frank on an application. Mr. Frank has also been working with M3 to try to purchase private submerged lands that occur on Lake Pend Oreille. And Mr. Frank is going to be submitting an application for his lot that is closest to them. And through the communication with Mr. Frank, there's been no comment of objection or anything like that. But I will further what Mr. Brownlee said, which is that he's to be okay with it. He hasn't said anything negative about the project. Through my experience with Department of Lands, working with Mr. Frank as much as we have in the past couple months, I would imagine if he has an objection, he would have definitely let me know about it. But to the question you originally asked, we have not received something saying he's in support of it, and we haven't received anything saying he's opposed to it. We've just worked with him, and he hasn't mentioned it at all.
Okay, and I was just curious because it was mentioned at the beginning, and just wanting to make sure that I've got the documents that you have in your file, and you've explained that, so thank you.
You're welcome. So for conclusion, the dock drawings that were submitted by CBCA all appear to meet the community dock standards that are listed under IDAPA 20.03.04.015.02. The proposed dock system is less than 7 square feet per lineal foot of shoreline owned. The proposed dock does not appear to be a hazard to navigation. No portion of the dock is wider than 10 feet, and there is at least a 25-foot buffer between the dock and from adjacent littoral lines. IDL acknowledges that most of the concerns raised by the objectors revolve around upland issues over which IDL does not have any jurisdiction. The issues raised deal with the septic system approval, the vacation of a road leading to water, and the subdivision of lots. Again, those issues are outside of IDL's jurisdiction, although rearrangement of individual lots through the county's processes could impact the location and layout of the community dock system. The LPA rules address that scenario. IDAPA 20.03.04.020.05B provides for rearrangement of community docks and commercial navigational encroachments may not require a new application for an encroachment permit if the changes are only internal. The department shall be consulted prior to modifications being made and shall use the following criteria to help determine if a new permit must be submitted. Overall footprint does not change in dimension or orientation. No increase in the square footage as described in the existing permit and in accordance with paragraph 1513A occurs. This only applies to community docks for the increase in square footage. And then also that the entrance and exits of the facility don't change. Based on that provision, if the individual lots are rearranged or the road is not vacated and the location of the docks must therefore have to shift, it is likely the changes still would be within the same footprint. As long as there's still 55 feet to the southern property boundary and 102.5 feet to the northern property boundary, IDL would likely find that everything that occurs inside those boundaries would be within the overall footprint of the community dock system. Additionally, the overall square footage could not increase as stated before. The entrances and exits of the facility would likely not be affected, as that statement typically refers to marinas that may have only 1 or 2 entry or exit points. However, the CBCA community dock system is made up of multiple docks, and it would be difficult to apply that requirement on the system. Based upon the rules and regulation IDL is required to follow when processing applications, IDL recommends approval of the community dock system in Camp Bay, contingent upon CBCA providing proof of littoral ownership of that entire shoreline. CBCA is also asking for a boat launch on the south side of the bay. The application provides that the launch will be able to be used by other residents on the south side of the bay and Camp Bay residents. CBCA justified its need by citing the location of the nearest launch and the reduction of traffic on a dirt road leading away from the site. Additionally, the launch appears to extend deep enough into the lake to be used year-round. IDL's guidelines typically do not allow private communities to install boat launches based on the wide availability of public boat ramps. If the boat launch is approved, it is recommended that first responders have access to the launch in order to provide another year-round launch site, as there are only 2 launches in Bonner County that can be used during low water, the Holt boat launch and the Garfield Bay boat launch. If the boat launch is approved, IDL recommends the construction of the launch follow the standards listed below. Concrete must be reinforced for added strength and durability. Concrete should not be poured below the artificial high water mark unless the lake or river can be kept isolated from the concrete. Pouring concrete into water is prohibited due to the effects on aquatic biota. Reinforced slabs may be poured into forms above the water line and then pushed into place. A cofferdam could also be constructed around the boat ramp area, and the ramp can be poured in place. Other methods that keep the work area dry may be used at the department's discretion. All authorized boat ramps shall be constructed in a manner to protect the toe of the ramp from boats power loading and power unloading. This may be done by extending the concrete ramps past the prop wash zone or by placing riprap at the ramp toe. And finally, boat ramps shall be constructed to prevent the ramp from acting as a conduit for stormwater runoff. And that completes my statement, Mr. Hearing Officer.
Okay, thank you, Mr. Hamer. So as we said at the beginning, then we'll turn this back to the applicant to provide any closing comments that it wishes.
Thank you, Mr. Hearing Coordinator. Bill Brownlee, M3 Companies, one of the owners of the company. So if you could share screen with me again, I want to go over a couple things to answer some of your questions that you raised. Is that possible?
So Chris Gozo, if you could enable a screen share with Bill Brownlee, I'd appreciate it.
Yes, you should have the ability to share a screen.
Thanks, Chris.
Thank you.
Okay, so the question before we get into the specific documents was really about the assignment of the littoral rights, how that's working. We've got Camp Bigfoot, and as well as we have the M3ID Camp Bay. So we acquired the property in June of this year. The set approved by the corporation. Title was legally passed to M3ID Camp Bay. There's been no challenges relative to the title passing to M3ID Camp Bay from Green Enterprises. We subsequently sold the estate parcel 1 to Camp Bigfoot, but prior to that sale, we had recorded the assignment of the littoral rights, which was recorded in Bonner County, as you can see here, on June the 29th of 2021. This assignment of an assumption of the littoral rights is for the entirety of the 3,100 feet of the littoral rights on the bay, which included the 660 feet of Camp Bigfoot and the remaining approximately 2,500 feet of approximately 2,500 feet remains in M3ID Camp Bay and is subject to the assignment as well for all of the waterfront lots. With respects to a couple of other questions that have come up, excuse me, slide this over to my other screen here, sorry. It's hard for us old dogs to learn new tricks with all this Zoom stuff nowadays. So additionally, we made the initial application and it was approved by Green Enterprises by Jim Green in May, as discussed. Subsequently, in June of this year, we acquired the property. So now we represent the applicant, which is the declarant for Camp Bay Community Association. We are the declarant. We provided IDL the assignment of the littoral rights that I just discussed. One of the other issues that was brought up was the bay itself and what we are doing relative to any type of pollution that's being caused in the bay. Eric Skinner discussed, but what we have done, Mr. Hearing Coordinator, is we went in and initially cleaned up the entirety of the, starting from this end all the way around. There was some older structures that were in the bay that were part of the 21 leased lots. A lot of those lots did not appear to have a septic system that was servicing those lots, and a lot of the docks were in disrepair, including the boathouses that were also on the littoral line. So we've taken significant steps to clean that area up, which is a major improvement to the bay. The other questions that you raised was the Jim Frank consenting to this and approving of it as the nearest property owner. Mr. Frank lives in this home right here. He would be the one that would be the most affected by the docks. This is Mr. Frank's home, and this is the community docks that are extending out, and this is the boat launch. I called Mr. Frank. He's on his way to Washington, but he said that he would, if it would be helpful and you would approve it, he would submit an email tomorrow stating approval of this application. So if you would like to have that done, I can have him send it in to Mr. Amar tomorrow. Would you like to have that, Mr. Hearing Coordinator?
That'd be fine. That'd clear that issue up. Thank you.
All right. There's been a lot of discussion about the green enterprises and the internal trials and tribulations that the family has gone through with the differing things. That really has no bearing on this issue. So I hope that has no factor in consideration for this. The factors for the purpose of this hearing are very narrow and as discussed, and that is the physical characteristics of the area, the ability to do this with the littoral rights that we have, the square footage of docks that are allowed, utilizing the methodology that has been used by other developments on lakes monitored by IDL. We fall within the total square footage allowed. We fall within the construct of this. We have worked very diligently with Mike and Justin, reviewing the application, making sure that we were meeting the intent of the code in order to enable us to construct these docks proposed. And we really appreciate and have benefited from the advice that IDL has provided to put together an application that does so. One of the things that was also raised was the Fish and Game component of it. And if you look at Fish and Game's letter, in the very closing paragraph of the June 25th letter from Fish and Game, I've highlighted in yellow, but I'll read it. By following the construction techniques outlined in the application and completing the work during the fall drawdown and winter pool, most negative impacts to water quality should be, should say be, but it says by temporary and minimal. So Fish and Game is the authority on the impact to the fish and the game in the area, as well as the water quality in that location. And as you had mentioned, neither Fish and Game nor Army Corps of Engineers attendance on this hearing, and neither has provided negative comments to the best of our knowledge. That, if there's any questions that you may have for us, I would be glad to answer those. And if I don't have the answer, I'm sure that Alex does. We appreciate everyone's time in order to review this application. We would ask for approval of this application and that the application be viewed in the context of what IDL has outlined in the staff report on our application. I appreciate everybody's time. Thank you.
Mr. Brownlee, thank you. The assignment that you had up, was this a document that you were providing in response to the department?
We have provided this assignment to the department.
Okay. I'm not sure that I've seen that. So
we can provide this again in the morning as well.
yeah, that would be great. And my understanding is you've provided the PowerPoint already. the assignment then would be quite helpful to see.
Certainly. We will email that as soon as we complete the call here.
Okay, thank you. Mr. Holt, your written summary then of what you described, as I said, if you can get that in by noon tomorrow, then we'll put that into the record.
Yeah, I can do that.
Okay, thank you. So with that, I appreciate everybody taking the time tonight. I appreciate hearing from the applicant. Also appreciate taking in the comments from everyone else. As I said at the outset, I now have a requirement to consider the record, write up a preliminary order that is then reviewed by the director of the Department of Lands, and you all then will be seeing a final order that will come out discussing this application. And with that, Chris Gozo, I would like to go off the record. Thank you, everyone.